Good morning, everybody. We'll be starting shortly. If you're a victim or anybody that's on a case and you're not court staff, please keep your camera off until the judge address your case. So Ms. Lester, turn your camera off until the judge calls your case, okay? Thank you. Hi, Judge Missy, we can't hear you.
Can you hear me? Good afternoon.
Good afternoon. How are you?
Let's see. Make sure I got my volume turned up. Hold on.
Yeah, we can hear you now.
Can you hear me now? Okay. All right, we're ready to start.
Yeah, I gave you a reset date. It's in the chat. It's gonna be on December the 4th.
Okay, December 4th.
Yeah, because the week after that is the holiday, so we would.
Oh, that's right. We're cutting in.
Mhm.
All right.
And we do have getting a Spanish interpreter on the line soon. Miss McLeod should be joining us also, so.
Okay. I think I just saw her.
Good afternoon, Your Honor. I'm
Good
here.
afternoon. How are you?
I am very well. Thank you for asking.
Good. All right.
Good afternoon, Your Honor.
Good afternoon, Mr.
Yeah, just to
Martels.
let the court know, I'll be representing Mr. Lorenzo, number 10. He's the client that needs an interpreter.
Okay.
Okay, thank you.
Thank you. All right, ladies and gentlemen, we'll get started. Good afternoon. My name is Judge Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after the arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been offered by the state at this juncture. I think you've already heard the reset date for the SAP calendar, which is December the 4th. I also want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I also want to remind the defendants of your constitutional rights. I want to remind you that you have a right to remain silent, that anything that you state about the facts, the circumstances, and the occurrences can and will be used against you. The state is here and they're listening, so listen to your attorneys. And you also have obviously at this juncture a right to an attorney. And you should have spoken to your attorneys prior to court and know who they are. So listen to their guidance. All right, who do we have first, deputies?
Position number 13, Mr. Nelson.
Okay. This is 25 CR 007387Y State versus Josiah Nelson. The charge is giving false information to law enforcement. Pretrial?
First arrest. A resident of South Carolina. He has a fugitive hold, so he's about to go.
Okay. State?
Yes, Your Honor. This is the case of the state of Georgia versus Josiah Nelson. On October 14th, 2025, APD Officer Threewitz, THREEWITTS, conducted a traffic stop on a white Toyota Corolla at 387 Joseph E. Lowry Boulevard, Southwest. After a tag check revealed the vehicle had no valid insurance. Upon approach, the officer observed 3 people in the vehicle. Mr. Nelson was a passenger. He was not the driver. The officer detected a strong odor of burnt marijuana and observed an ashtray containing marijuana roaches in the center console. Mr. Nelson exhibited suspicious behavior, including heavy breathing, excessive movement, and repeatedly looking over his shoulder. He initially provided 3 false names and claimed to be 15 when he was actually 17 years old. A record check revealed that Mr. Nelson had an active warrant out of Columbia, South Carolina. The warrants were confirmed by South Carolina units. The state's recommendation is a $1,000 surety bond and for him to be released to South Carolina due to the active bench warrants.
All right. So if you're recommending a surety bond and a release, it's either or, which would you like to recommend?
We can do the release to South Carolina.
Okay.
Yes,
All
Your
right.
Honor.
All right, PD.
Thank you, Judge. My name is Brandon
Judge.
Tamani.
Hi, is it Tamani?
That's right, Judge.
Okay, thank you. Nice to meet you. I don't think I've met you before.
I have not met you either, Judge, but it's good to meet you.
All right, you too.
I don't really have too much to add. The defense wouldn't object to the release. His family lives in Columbia, South Carolina. I've told him that essentially that he needs to keep his address updated with the court and make sure that he has, good contacts so that, he doesn't miss any court dates. I'm not sure how long he'll be in custody there, but, as long as he's keeping track of his court dates, then he should be fine.
All right. All right, I'm going to release Mr. Nelson to his fugitive hold. And generally, I guess it just depends. And pretrial already has it on the record. And so I would let me know if I give him a signature bond only to be released to South Carolina. And it is his first. Then I can do that through, and I don't usually say through the jail either, do I, Miss Lewis? But we certainly want him to be released to his hold.
I mean, you can do it through the jail or UJR, whatever your preference.
Okay. And I'll say per judge, UJR through the jail, but only to be, the condition would be released to the hold in South Carolina. And I think that's it. There's no victim per se, so there's nothing else that I need to add on that.
Your Honor, so that's a signature bond through the jail?
Correct. And we can, Ms. Lewis, should I give it an amount? We can give it a 5,000 signature bond through the jail.
That's fine if you want to do
Okay.
that.
Yeah, let's put,
5,000.
5,000. That should be it.
Hey, Judge, can we go to Pitts? I don't have his position number, but this is Pitts in front of you.
Okay, let's see. That looks like,
He's on the add-on calendar, Your Honor. Oh, he's
oh,
number
that's the
one.
add-on.
I'm sorry, he's
Number
number
one.
one on the calendar.
Right, Gabriel Pitts.
Yes, Your Honor.
Okay. This is 25 CR 007389H. Gabriel Pitts charged with battery, family violence, simple battery, terroristic threats, and acts. Pretrial.
10th arrest on probation for ag assault. 24 SC 003683. 2024 simple battery DV conviction. That's all.
All right.
Your Honor, the state is asking for $11,000 total surety bond in this particular case, with a breakdown of $5,000 for the battery, family violence, $5,000 for the simple battery, and $1,000 for the terroristic threats. This is based on the defendant's history in this case. He does have that aggravated, he is a convicted felon, does have that aggravated assault. Our records reflect 2 prior battery, family violence convictions back from 2005. This particular victim does have a protective order against this defendant based on this particular incident, which involved strangulation in regards to the battery, family violence. There was also kicking while she was down on the ground for the simple battery, and he did threaten this particular victim, thus the charged terroristic threats. The victim was not able to attend this court hearing, Your Honor, and so we're also asking that he have no contact with this victim. The victim in this particular case is April Price. In addition to that, Your Honor, we are asking a stay away from the location, which is 1441 Peachtree Street in Atlanta. And that is all from the state.
All right.
Your
And
Honor?
Attorney Cloud, yes.
Yes, Your Honor. My client was actually the victim in an attack by the alleged victim. If the court notices he has bandages on him because she brutally attacked him and stabbed him, he was in Grady for several days, Your Honor. And he really needs to get out of jail so that he can get appropriate treatment. I would ask the court to take all of that into consideration. I believe that when it comes to trial and all the facts have been sifted out, we will see that my client was actually the victim in this case. What he tells me that is this particular victim, she was at his home. She came to where he lived. And she got into an argument with him and she attacked him. And she was arrested. So I believe that's the reason why she's not able to appear here today. So if the court is disinclined to give my client a signature bond, I would ask for the lowest possible bond for him so that he can get out of jail, go home to get proper treatment for his injuries, Your Honor, and that he'll be able to work with his attorney to properly defend against this case.
Your Honor, she was not arrested in this case. She is not in jail. We spoke to her on today. She is at work, which is why she's unable to attend this Zoom meeting, Your Honor.
Well, is the state disputing that she stabbed him?
They locked up.
Ms. McLeod, the facts of these cases for a jury to decide. We're here to
Okay.
decide whether he's eligible for bond. The state has presented its case as to why and we'll allow the judge to make the decision on what type of bond they need to make.
All right.
She slit my throat.
Hold on.
Miss-
Who's that talking?
Mr. Pitts, don't say anything. Okay, I will speak for you.
Yeah, no outbursts from the defendant. Not been given permission to speak. All right, I'm going to order, and this is based on his history as well. Until it can be sorted out later, I'm going to order the $11,000 surety bond, $5,000 on the battery, $5,000 on the simple battery, $1,000 on the terroristic threat. I'm going to order there be no further contact with April Price and to stay away from 1441 Peachtree Street. And that would
Thank
be
you,
the
Your
order of the court.
Your Honor, she slit my throat, I almost died.
Mr. Pitts, don't say anything. The justice has already made our bond order, and all of this will come out when we go to trial.
All right, thank you.
Your Honor,
Thank
can you go through that rundown again?
That's 5,000 on the battery family violence, 5,000 on the simple battery, 1,000 on the terroristic threats, for a total 11,000 surety.
Gotcha.
Thank you, Your Honor. That
Okay, thank
concludes
you.
my business before the court today. Am I be excused?
Yes, you may. Thank you.
You're welcome.
All right, next we'll go with position 7 and 8, Mr. Kimber.
This is 25 CR 007375A and Tavius Kimber in position 7, charged with battery family violence. In the second case, ending in 7376A, charged with simple battery. I think they have two different offense dates, September 10th of 2024 and November the 3rd of 2025. Pretrial.
17. He went to felony earlier, 15,000 split was that bond. 2015 criminal damage in the second, burglary in the first degree conviction, 08 burglary conviction. That's it.
State.
Your Honor, the state is asking in position number 6, as you are aware, he's charged with battery family violence. The state did
It's
upgrade
position 7.
Position 7.
7. Okay.
Is the battery family violence case. That particular case, the victim in the case is Sharonica Lewis. The state is asking for a $5,000 surety bond, no contact with Ms. Sharonica Lewis, a stay away from the location, which is 266 Beeler Drive, Beeler, no weapons in this particular case. She is the victim in both of these cases, Your Honor. As Your Honor stated, these did happen on 2 separate dates. So after the first time, there was a family violence incident. This is the second one. We're asking for this be a surety bond based on its history. As stated, he is a convicted felon several times over. Also, he is also in on a felony offense that includes possession of a firearm by a convicted felon. In the battery case, he punched the victim in the eye, causing her to have a black eye. And in the simple battery family violence case, Your Honor, the state is asking for a $3,000 surety bond. In addition, we're asking for no contact with Ms. Lewis or any of her family members and to stay away from the incident location, which is the same. Again, this is based off of his history. We did have contact with this particular victim as well. She did ask for contact as she wanted him to return home. However, due to his history, as well as the fact that he has 2 open cases against this victim, and it seems to be that he is escalating, we're asking for no contact and to stay away from that particular location. Nothing further from the state.
All right. PD Bartels.
Yes, thank you, Your Honor. I did speak with Mr. Kimber. I also have spoken with the alleged victim, Ms. Lewis. Mr. Kimber does have 2 cases, number 7 and 8. He does deny the allegations that he was the primary aggressor here. However, he is employed. He has a job working at the airport, Your Honor. He works maintenance for Unify Systems. And that job is on hold until he can clear up the current charges. But I'm told he is employed. He was born in Atlanta, I'm told, and all of his extended family is here, Your Honor. So he does have a job. He does have ties to the community. Again, I spoke with Ms. Lewis. She indicated that she does not want to see him prosecuted. She is okay with no further violent contact. but I'm also told that Mr. Kimber can stay with his father. So a no further contact order would not be a problem in that regards. We would just ask that he be able to go to the residence with the police and get his property if the court does order no further contact. Regarding bond, we would ask for a $1,500 bond on number 7, the battery, and the $1,000 bond on the simple battery. I think that would be sufficient to guarantee his presence in court. Nothing further right now, Your Honor.
All right, on position 7, we're going to order a $4,000 surety bond on the battery family violence. With that $4,000 surety bond, then I order no further contact with Sharonica Lewis. Stay away from the incident location, and no drugs, alcohol, weapons, or guns while on bond, as is the case with every case. And he can have a one-time law enforcement escort to return to the location to retrieve any of his personal property, but he must set that up with law enforcement since he is supposed to stay away from that location.
Okay.
Excuse me.
Yes.
Yes, in that report, I never had a black eye.
Who's speaking?
Sharonica Lewis.
Okay.
I've never.
That's not how you do it in my court.
Okay.
I'm not going to debate the facts with you, but I have 2 questions and I need to swear you in first. I didn't know you were here.
Okay.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Put your hand down for me. First question I have for you is, are you in fear of Mr. Octavius Kimber?
No.
Do you want to have any further contact with him?
Yes.
Okay. And that's all I need to know. This is not a trial. This is a bond hearing. And I want to make sure, first and foremost, is that you're safe and that you're free from any additional harm. Okay.
Yes.
So you can mute yourself now. Thank you. All right. And did you have anything else, PD Bartels?
Nothing further, Your Honor.
All right, 4,000 surety on the first case, and on the second case, it'll be a $2,000 surety bond on the simple battery in position number 8. And again, same conditions, no further contact with the victim, Miss Lewis, and her family members or relatives or co-workers. He is to stay away from the incident location, and no drugs, alcohol, weapons, or guns while on bond.
Okay,
Can I
thank you, Your
verify
Honor.
the location again for the order purposes?
Right.
Morris, what is that
Yeah.
stay away address, please?
I think it's 261 Beeler. Hold on one second. Let me
Is it 266? I had 266, but you can see.
Well, can you put in the chat for me to me, Miss Lewis, so I can get it?
It's 2661 Beeler Drive in Atlanta. Beeler.
And Your Honor, that was 4,000 on both charges? Sure.
No, 4,000 on the first and 2,000 on the second. The total is 6.
We can go to ACDC.
Okay. ACDC.
Are they ready? I don't think they're ready. Okay, well, we stay here. We'll stay here. Position number 3, Mr. Hodges.
Okay.
No. Come on.
This is 25 CR 00737 1E, State versus Robert Lee Hodges Jr. And the charge is lauder and prowling and willful obstruction of a law enforcement officer. Pre-trial?
My bad. Who is this?
This is Hodges,
It's
position 3.
33. Got 33 total. On probation for burglary in the second degree. Has a warrant out of Forsyth for escape. Date of that warrant is October 17th, 2025. He had a 2023 parole, 2022 parole violation, and the 2012 burglary, possession of tools conviction. That's it.
All right.
Mr. Hodges, I think, already has a $2,000 bond, $1,000 on each charge, one of loitering and the second of obstruction. This is a surety bond, and the state does feel that a surety bond on these particular charges is appropriate. The amount is appropriate as well, based on the fact that he is a convicted felon with 33 cycles that include multiple felony burglary convictions as well as theft and drug offenses. In this particular case, he was inside of a construction zone at 2 o'clock in the morning, loitering. In fact, the caller suspected him of stealing copper wire. He had to pass several signs forbidding entry. And so based on that, the state is asking for the $2,000 total surety bond with a breakdown of $1,000 on each charge. And a stay away from this particular incident location, and I can put that in the chat for you.
All right. Martel?
Yes, thank you, Your Honor. I have spoken with Mr. Hodges. We would ask the court for a signature bond if the court believes he qualifies. He was born in Atlanta, Your Honor, and has lived here all of his life. All of his family, including his mother and all of his siblings and extended family, are here in the metro Atlanta area. He is not employed right now. I'm told he has severe arthritis. He's working on getting disability for that. So if he qualifies, just based on the charges, and I would note that there's nothing in the warrant about him being found with any copper or any stolen items. He's not charged with any type of theft. If the court believes he qualifies for a signature bond, that's what we would ask for. Otherwise, we would ask for a $500 good bond on each charge, and nothing further right now.
All right. I'm going to, based on his cycles and history, I'm going to leave the bonds where they are with the $2,000 total, $1,000 on each. Stay away from the incident location and no drugs, alcohol, weapons, or guns while on bond.
Yeah, thank you, Judge.
Uh-huh.
Next, we'll go to position number 5, Mr. James.
This is 25 CR 007373C. And this is State versus Ken J. James, charged with 1 count of battery, family violence, 2nd count, criminal trespass and damage to property. Pre-trial.
13. You got an open case out of the cab, suspended license, battery, cruelty in the third. Got a 2024 criminal damage to property, 2nd degree arrest, and probation violations from 24 and 2 from 23. That's it.
Your Honor, in this particular case, the state is asking for a $3,000 surety bond and no contact with the victim, Alona Taylor, ALONNA, traditional spelling for Taylor. We're asking for a stay away from the incident location, which is 3931 Adamsville Drive in Atlanta. No drugs or alcohol, and we're asking for a breakdown of $2,000 for the battery, family violence, and $1,000 on the criminal trespass for that total 3K surety bond. This is based on his history, Your Honor. He has a 2022 battery family violence case, which was against a different victim at the time. He also has another open case in our office under 25 CR 003367C. The victim, we did speak with the victim in this particular case. She is asking to have contact and not to have the stay away. But based on his history of battery family violence against a different victim, we are asking for no contact and to stay away from this particular location. Nothing further.
All right, Mr. Bartels.
Yes, thank you, Your Honor. I have spoken with Mr. James. I'm advised that he was defending himself in this instance. He indicated that she was the alleged victim was the aggressor in terms of trying to tase him first. And he slapped the taser off of his body, which might have caused some damage to it. But we understand that that'll have to wait till a later date to adjudicate that. He is wanting to ask for a signature bond if he qualifies. He is employed full time at GXO Warehouse, I'm told, on Fulton Industrial Boulevard as a forklift operator. I'm told that he was born in Atlanta, has lived here all of his life, and his extended family is here. So he has ties to the community. I believe they do not live together at this time. Um, we would ask the court to consider no further violent contact based on what the alleged victim has indicated, but he does, have somewhere else to stay if there is a no contact order. And if he doesn't qualify for a signature bond, we would ask for a $1,500 total good bond, 1,000 on the battery, and 500 on the trespass. And nothing further right now.
All right. I'm going to order the $3,000 surety bond, 2,000 on the battery, 1,000 on the criminal trespass. No further contact with Alona or Alana Taylor. Stay away from the incident location at 3931 Adamsville. No drugs, alcohol, weapons, or guns while on bond.
And Judge, we also would ask, I don't know if he has any property there, but we would ask that he be able to go back once with police to retrieve that if he does.
I think the victim is on the line, Judge.
Is she on? Let's see. Ms. Taylor?
Yes, ma'am. Can y'all hear me?
Need to see you.
Okay.
Are you driving?
No, ma'am, I'm parked.
All right. Do you wish to address the court today?
No.
Okay. All right. That's fine. This is not the trial. This is just the bond hearing. So we appreciate you for coming. And I've given my ruling, which is I don't know if you heard that, a $3,000 surety bond.
Mm-hmm. Yes, ma'am.
2,000 on the battery, 1,000 on the criminal trespass. He is to stay away from you right now. We want no further contact, and to stay away from that 3931 Adamsville Drive. Does he have any personal items at that location?
Yes, ma'am.
Okay. I'll give him a one-time police escort to come back to that location just to retrieve his personal belongings, and he needs to arrange that with an officer. All right. No drugs, alcohol, weapons, or guns while on bond. Mr. Bartels, I think your client has his hand raised.
Yes. Do you have a question, Mr. James?
Yes, good afternoon, Judge. That is my place of residence. So if I don't, if like, how they, I mean, how do I supposed to stay away from somewhere that I stay at? Like,
Because you're on bond for a criminal case, and while you're on bond, you need to stay away, and I've allowed you one time police escort to go back and get some personal belongings, but while you're on bond, you need to stay away, so make sure that the victim is safe.
yes, ma'am. So I stay on the street.
Okay.
Thank you, sir. Thank you, Judge.
Next, we got position number 9, Mr. Lester.
Okay. This is 25 CR 007377C, John Joseph Lester, charged with 1 count of battery family violence, 2nd count of hindering a person making an emergency telephone call. Pre-trial.
I got first.
State.
1 second, Your Honor. I'm looking for
Okay.
his information.
Your
In
Honor,
this
I believe, I'm sorry to interrupt. I believe Ms. Lester is here.
Wonderful, thank you.
Yes.
And so the state is asking in this particular case for a $5,000 total surety bond with a breakdown of $2,000 on the battery charge and a $3,000 on the hindering 911. I'm sorry, a total bond of $3,000, $2,000 on the battery, and a $1,000 on the hindering 911 call. This is based on the nature of these particular offenses. In this particular case, just to let the court know, the victim in this case is Noreen Lester. She is the wife of the defendant. They have been married for 25 years. They do have children, although adult children. I think one of those children is currently living in the home with them. She is asking for contact due to the nature of their relationship. According to the police report, she did sustain a lot of injuries in this particular case, including a black eye, lacerations, bruising, and just seems to be a heated incident that also involved alcohol. So the state would be asking for a no violent contact in this particular case with Noreen Lester. The state is asking for a stay away in this particular incident as well. She indicated that Mr. Lester has a drinking problem, and when he drinks, he gets violent. And so, based on that, we would ask for a stay away from the location of 655 Huntwick, HUNTWICK Place in Roswell, Georgia. That is one word. Nothing further from the state.
All right, Mr. Bartels.
Yes, thank you, Your Honor. I spoke with Mr. Lester. I also spoke with Ms. Lester, who, as the court can see, is here on the Zoom call. As the court knows, Mr. Lester is 64 years old. This is his first arrest, Your Honor. It appears he has no criminal history at all. I'm also advised that he is retired. He was in the Marine Corps, including active duty and reserves. He also worked in the financial industry, including for Citibank, and has been a model citizen judge based on that record. He and his wife do have two children. They're 22-year-old twins, and I'm told that one of them lives in the home. And I am advised by Mrs. Lester that she is not in fear of her safety and is asking for a no further violent contact. So based on that and based on his entire lack of history and Mrs. Lester's report, we would ask the court for a signature bond. We understand no alcohol and drugs is the weapons. That's going to be a standard condition of bond. So that is going to be in effect. And nothing else right now, Your Honor.
All right.
We would ask that he be allowed to sign his own bond.
Ms. Lester, do you wish to address the court today?
I definitely do. Thank you, Judge.
Hold on.
Okay.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
I have 2 questions for you. Are you in fear of Mr. John Lester?
Not at all.
Do you want to have any further contact with Mr. Lester?
No, I would like to have contact with him.
All right. And I've heard the statements I think that you've given to the state regarding that contact. The problem I'm having is that this just happened yesterday, barely 24 hours. We usually require or want there to be a cooling down period so that you will be safe and hopefully this incident will be over and there will be nothing further to deal with. But we haven't had that period, and so I usually don't allow people to go back home so fast.
Well, Your Honor,
Understood.
Your Honor, I will say Mrs. Lester did tell me that she is ready. She's planning to go out of town. So there actually would be some period apart. How long are you going to be out of town, Mrs.
I'm,
Lister?
thank you. So, Your Honor, I travel for work and I am leaving early Monday morning, going out of state for the week. Uh, that would allow further de-escalation. Again, I am not worried about it. He's got no history of this at all. I'm going to be out of town anyway. I don't know how better to explain it than that. I'm going to be gone for a week as it is.
Okay. And I don't know if I need to order Mr. Lester to go to any courses or to get start any type of treatment.
Can I speak to that, Judge?
Yeah.
Yes, so I am absolutely committed to getting him support and myself support, counseling through EAP or elsewhere to get us through this so that this does not happen again. This was a one-time occurrence. I think the only thing I disagree with, he does not have a drinking problem. It escalated that night because we had a couple cocktails. He does not have a drinking problem. So I want to clear that up. And I think the other thing I just want to clear up, if I may, when I was on the phone with 911, I told John that I was on the phone with my sister. He did not know I was on with 911 when he took my phone. He respects police. He has very high regard for them. He would never take my phone from me if he knew I was on with 911. He thought I was on with my sister. So he took the phone. So I just want to make that clear. That was not obstruction. It was obstruction of me talking to my sister.
Well, it doesn't matter. It was someone that you considered
Yeah.
at that point to be in line to help you, whether it was your sister or 911, shouldn't take the phone at all. And
Yeah.
obviously you wouldn't have called somebody for help if you didn't feel like you needed help.
Understood.
I'm going to put
Understood.
words in your mouth, and we're not here to debate the facts
Oh,
so
understood.
much today, but
And Your Honor, may I just say this one thing? The state's concern is that as of yesterday, the victim in this case reported to police that when he drinks, quote, he turns crazy. And in the warrant, it also states that at one point she did inform him that she was on the phone with 911. Like you said, we're not here to debate it, but the story, of course, we know in the cycle of abuse, recanting is something that happens when victims actually testify. So there is a concern that, like you said, there's been less than 24 hours. The story has changed. And she's saying she's going out of town on Monday. He will be released today, on Saturday and Sunday. So we are asking again that there at least be some portion where he has to stay away from the home.
okay. And that is our concern. He will probably be home Sunday before you leave, Miss Lester.
Mhm.
So I'm going to order the 3,000. Well, let me ask this. Do you know if he has somewhere else to go stay?
Are you asking me? I'm sorry. Are you asking me?
Mhm.
He does not. I mean, I could leave. I could leave tomorrow so that he has the home to come to home to. I could leave tomorrow. I mean, if
Well,
that's
that's normally not what I order.
right.
Because normally, again, we're here for the victim, not for the defendant.
Understood.
And I don't know. I know you'll be out of town for a week, but he may have to stay at a hotel. Didn't have a friend or any relatives here.
It would have to be a hotel, Your
I
Honor.
believe it. I believe it would be a hardship for him, Judge. We would just ask the court to consider what Ms. Lister has said. Apparently, from what Ms. Morris is saying, there have been, inconsistent allegations, and rather than debating that, that can be resolved at some other point. But it would be a real hardship for him. He's 64 years old, and Mrs. Lester told me this is extremely uncharacteristic of him.
Oh, but we have conflicting information. I want to make sure that she's going to be safe at least the day before she leaves anyway. And I don't normally do this, but if she's going to be gone on Monday, then he can't return until Monday till we know that she's gone.
Well, that could be a condition of bond.
Um, well, what I'm going to do is I'm going to order the $3,000 signature bond since it's his first. My gut tells me not to, that there may be something else going on, but what I'm going to order is the $3,000 signature bond through pretrial. And I guess he'll be at a level 1.
All right.
He
Thank you,
is,
Judge.
and hold on, there's other conditions.
Sure.
He is to stay away from the incident location, which is the marital home. He needs to stay away until Monday at 5 p.m. He can go back at that point as long as the victim is not there. If he goes back and the victim is there, he will be in violation of his bond. So I don't know. I'll do no further violent contact so they can at least have minimal contact to know that she's gone Monday by 5 o'clock. Then he can stay there. I'm going to order that he take an anger awareness class, 2-day anger awareness class through pretrial. I'm going to also order, I can do 1 or 2 of these. And state, tell me what you think. I can order an ADET, which would evaluate him and tell us whether he needs treatment, or I can order him to go to AA classes.
I would want an alcohol drug evaluation and treatment.
All right, I'm going to order an ADET.
Your Honor, I do think that would be the appropriate of those two. We wouldn't disagree with that.
Okay. All right. So I'll order an ADET. They'll evaluate him and he will follow along with the recommended treatment. No drugs, alcohol, weapons, or guns while on bond.
All right. Thank you, Your Honor.
All right.
Judge,
Thank you.
what's the breakdown, please?
Oh, I'm sorry. 2,000 on the battery, family violence, 1,000 on the hindering.
Thank you, Your Honor.
All right. Thank you.
Thank you, Judge.
All right.
Judge, also, Justin, before we go, I know on the position, I'm sorry, but there was just want to make sure that we are clear on one of these individual we just did a bond on. There was a charge that was not on the counter and the state NOD, and I just want to make sure the NOD, it was on Mr. Hodge, position
Okay.
number 3.
You're free to go, Ms. Lester. Thank you.
Thank you.
Okay. We're going back to Robert Lee Hodge. Yes.
Yeah, position number 3. I just want to make it clear that his surety is $2,000 because they NOD the criminal trespass, but there's a bond to that criminal trespass. So I don't want them to think that they're gonna ask what happened to the criminal trespass charge. So I don't want to make sure that the state sent over that NOD letter on position number 3 for the criminal trespass. So he won't post a bond on that charge.
Okay.
Yes, we did.
You did? Okay.
Okay.
Okay, thanks.
Because nobody mentioned anything during the time.
Right, and I didn't have it, right.
Yeah.
All right, thank you, Ms. Marsh. You all have already sent that over to Ms. Lewis.
Yes, ma'am. We've sent all the NODs for all the cases over earlier this morning.
Do you have that, Ms.
I can send
Lewis?
it to Ms. Lewis. We sent
No,
it
it
to
doesn't come to me, it goes to the jail. I just, see,
Oh.
the jail always asking me for it, but it comes from the state and I don't have access to the.
We don't have that. It goes straight to the jail. Okay.
It's supposed to go straight to the jail.
All
But the
right.
jail-
I'll forward you
I
those
just stated-
emails.
Yeah, records
I'll
always
forward you
asking us for it.
All right, thank you. Who do we have next, deputies? 16? Okay, good afternoon.
Good afternoon. And they heard their rights, Your Honor.
All right, ACDC, for those defendants there, you have a right to counsel, which you should have already spoken to your attorney by now. You also have a right to remain silent. Remember that anything that you state about the facts and circumstances or the occurrences of your cases can and will be held against you. The state is here and they are listening. And these are bond hearings. It's not your trial. So we'll listen to limited information but it will be regarding your bond for today, okay? And remember, this proceeding is being live streamed and recorded, so it is on YouTube as well. So govern yourselves accordingly, listen to your attorneys. All right. This is position 16, 25 CR 007384F. And this is Sanit maybe Sandhu. So I apologize if I'm mispronouncing your name. We have 5 charges: driving with improper erratic lane change, distracted driving, the wireless device DUI, less safe, reckless driving, and distracted driving, failure to exercise due care. Pretrial.
2021 DUI dismissed. 2016 driving while impaired conviction. That's it.
All right, state.
Yes, Your Honor. On November 13, 2025, Officer Christensen with Roswell PD observed a vehicle on the Georgia 400 northbound off-ramp in Windward Parkway in Alpharetta. The vehicle was leaving excessive space between cars, failed to maintain a single lane, and swerved during a turn. He also observed the driver holding a cell phone and instructed her via the PA system to put it down. She responded by extending her middle finger in the officer's direction. The officer initiated a traffic stop. The defendant had red, watery eyes, soft speech, and difficulty locating her driver's license. The officer detected a strong odor of alcoholic beverage emanating from the vehicle and later on her breath. When asked, the defendant's travel explanation was inconsistent and did not make sense. She was barefoot and struggled to find and put on her shoes. She admitted to drinking wine at Cross Restaurant and declined any field sobriety test. The state's recommendation is a $2,000 surety bond, no alcohol, drugs, or weapons loan bond.
What's the breakdown?
Your Honor, I'm so sorry, I did not do that.
Well, there are 5 charges, and you said a 2,000 surety.
Yes, Your Honor.
So I don't know, is it 500, 250? And how did you come up with 2,000?
We can do 1,000 for the DUI, and let's see for the other ones, 5 charges. 1 second, Your Honor.
So 250 on the others.
Yes, Your Honor.
All right. Go ahead, PD Tamani.
Thank you, Your Honor. Ms. Sandhu is 32 years old. She's been living in the Atlanta area for the past 2 years. Her family lives in Atlanta, including her parents. She said that they will be able to post her bond. She isn't working right now, but she has told me that her parents have arranged for her to enter into an inpatient treatment facility when she's released. So her parents are planning on taking her there as soon as she gets out. She's also, her family's also in the process of hiring a private attorney. So that attorney should be able to keep up with her address and everything, and wherever she ends up in the facility. Judge, we would just ask for a reasonable bond in this case.
All right. Well, I will order the $2,000 surety bond, which will be $1,000 on the DUI and $250 on the other 4 charges, for a total of 2,000 surety. Looks like no driving while on bond, except to court to see her attorney or to a doctor's appointment, which hopefully she will take Uber or be taken by her parents. And I was going to order her to make sure she completes and complies with this inpatient treatment program while on bond. And no drugs, alcohol, weapons, or guns while on bond. And I believe that would be it. Anything else, counsel, to leave out?
No,
Nope.
Judge.
No, Your Honor.
Judge, you said no driving. Her licenses should be suspended.
They should be. So
So
we'll
there's
just
no
say
driving unless a valid license is issued by DDS.
that would be correct. Yes, let's say it that way. I guess that's it. Thank you.
Next, we'll go position number 11, Mr. Matney.
Where are we with the interpreter case?
Present, Your Honor.
Right, I'm trying to see where we are with this. I don't have to hold you too long. Deputies, is the interpreter case up or no?
Yeah, he's here. He's got to get interviewed.
Yeah, I can talk
Can
to.
that be happening while we're waiting?
Yeah, I'll just do all of Mr. Tamani's people while he's being interviewed by Mr. Bartell.
All right, which position again now do we have before us?
11.
11. All right, this is 25 CR 007382G, Chris Matney, charged with 1 count of fair evasion, the 2nd count of criminal trespass. Pretrial?
You said Motney.
Matney. Mm-hmm.
You got 8 total, 2025 probation, 2021 ag assault conviction, 2011 robbery conviction. That's it.
Okay.
Your Honor, the state is asking for a $2,000 signature bond with a $1,000 on each charge, one of fair evasion and one of criminal trespass. He already has a suspension from MARTA that lasts into December of 2025. We do ask that this one includes a stay away from all MARTA stations. In particular, we also ask that he stay away from the North Avenue station, which is the subject of this particular incident, which is at 713 West Peachtree Street. Nothing further from the state, Your Honor.
Let me make sure I understand. So he has a suspension from all MARTA right now to December?
December of
what you stated?
2025. Yes.
And
so we
then
ask
you're
that
right,
we ask part of his bond that he stay away.
that he continue with that suspension to December 2025. Okay.
Well, we're asking as a part of his bond that one of the conditions be that he stay away from MARTA stations as a part of his bond. I just want to make the court aware that he does have a previous suspension from MARTA that is up in December 2025, which is the subject of these charges.
All right, got it. Thank you.
You're welcome.
All right. PD Tamani?
Thank you, Judge. We wouldn't object to a $2,000 signature bond. Mr. Matney is 51 years old and he's been in the Atlanta area for the past 8 years. He told me that he stays at the Salvation Army on Lucky Street and that all of his personal items and documents are still at the Salvation Army, so he wouldn't be able to post a monetary bond at this point. That's it from the defense.
All right, I'll order that $2,000 signature bond through the jail. And that was 1,000 on each. With that signature bond, he is to stay away from all MARTA while on bond. I know that suspension ends in December, but he may likely be on bond beyond that. So we'll continue with staying away from all MARTA. You have to find some other means of transportation or take Uber. So you cannot ride MARTA while you're on bond. No drugs, alcohol, weapons, or guns while on bond. And I think that'll be it.
Next, we'll go position number 15, Ms. Price.
Hello. Hey. How you doing, Judge?
All right, 15, 25 CR 007383D, State versus Sharika Denise Price. 3 charges: criminal trespass, pedestrian in the roadway, and willful obstruction. Pretrial.
16. Got an open shoplifting. 2023 trespass arrest, 2022 failure to appear, 2021 failure to appear, and a 2020 ag assault arrest. That's it.
All right, state.
Yes, Your Honor. On November 14th, 2025, Officer T. Cox responded to a criminal trespass call at Red Carpet Liquor Store located at 687 Cascade Avenue Southwest. He met with Ms. Jordanos Tesfi, who reported that Ms. Price had previously been trespassed on October 26th of this year, and she had returned to the property. Officer Cox observed Ms. Price behind the business. He tried to speak with her, and she said, "No, you're not going to arrest me." Walk away from the business into traffic, causing drivers to stop abruptly at the intersection of Rogers Avenue Southwest and Cascade Avenue Southwest, and also Donnelly Avenue Southwest and Cascade Avenue Southwest, disrupting vehicles at nearby intersections. Officer Cox then requested backup and was able to detain the defendant. Your Honor, this defendant has a 2022 criminal trespass conviction from the same location and another one from 2023. She has several FTAs. So based on that, the state's recommendation is a $1,500 surety bond. That's $500 per charge. Stay away from the incident location. No further contact with Ms. Tesfaye or any other employee at the location. No alcohol, drugs, or weapons while on bond. That is all for the state.
All right. And PD Tamani.
Thank you, Judge. Miss Price is 28 years old. I wasn't able to get too much information from her. She did tell me that she has a schizophrenia diagnosis and that she takes injection medications for it. Um, she does live with her mother. I was able to get that from her. I do have some possible concerns about competency at this stage, but Judge, we would just ask for a reasonable bond. I do have a phone number. I did not have time to reach out. And what I'll do is I'll call that number and get some more information to our office once we are able to figure out what's going on.
I think she have 2 FTAs in her history.
Your Honor, I saw an FTA from 2021, probation violation from 2022, and another FTA from 2019.
Judge, also, there's somebody here on the line on behalf of Ms. Price.
Oh, all right. Who do we have?
Hi, my name is Joan. I witnessed Ms. Price being arrested, and I spoke to
Hold on. All right, and who are you to her? You just saw the arrest.
Yes, my name is Joan Fediro.
Okay, and you're not related to her anyway?
No, but I'm getting in contact with her family, and I also spoke to the business owner as well. And I just wanted to
hold on. I'm going to swear you in. Raise your
Okay.
right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. And so only thing I would want you to talk about briefly, and very brief, because you're not an attorney, you're not representing her, you're not related to her, is the conversation with her family. Is there someone here that, what did they say?
Yeah, so we're still reaching out to her family. I'm more so familiar with the business owner who pressed the charges, who said that she would really prefer that Ms. Price go to either a rehab center or mental health facility, and that she's also open to dropping the charges if she can go to either one of those sites.
When the owner couldn't come on and say that for themselves?
I wasn't able to get the information to her before the case started, but I can talk to her literally right after we finish this and make sure that she contacts the court. But she said she also told the officer that that would really be what she was interested in, but she pressed charges because the officer told her that that she would be able to get herself out of any facility that they took her to.
And Mr. Tamani, you're still trying to contact the family because you really need that.
Yes, Judge, yes. But I'm not sure whose phone number this is. I'll get that information.
Can you repeat the number because it might be my number?
It's 773-807-8. Okay.
Oh, that's your number?
Yes, that's my number.
So that's not a family member's number.
So at the time that she was stopped, someone who is familiar with her stopped behind me as well. He said that he was going to get her mother, and I'm waiting to hear back from him.
And I know this just happened less than 24 hours ago. So I know it's been a short period. I'm concerned about her getting out and winding right back here again. I'm concerned that we haven't been able to contact her family or someone that could be responsible for her and making sure she comes back to court, but also gets help or stays on her medication. So right now, I'm going to order the $1,500 surety bond so that that's $500 on each. And when she gets out on bond, or hopefully she will, I'm going to order her to continue with her medication and treatment. I'm going to order that she stay away from this red carpet liquor store and have no further contact with the employees there or customers. I'm going to order no drugs, no alcohol, no weapons or guns while on bond. And let's please, hopefully, Mr. Tamani, you can get in contact with her family or Miss is it Padro? Padero?
Padiro.
Padiro. And that Miss Padiro can get back in contact with you. Can you put your number in the chat for her, Mr. Tamani, so that she can contact you if she gets the family before you're able to?
Absolutely, Judge. Just one moment.
Okay.
And I have one clarifying question, Your Honor.
Mm-hmm.
Are there any court order programs that she can go to for
She's
either?
not been sentenced with anything yet. This is all pretrial. So I'm not going to order that until we know. It sounds like she already has a diagnosis and medication, but I don't normally do that as a condition of bond, depending on the situation. She already has a diagnosis, so we just need to find out what's going on. I mean, maybe she's not on her medication. So could be something that simple. But I'm ordering her to stay on any medication that's been prescribed and to get treatment to help her condition. But resources are very limited, especially at this time since she's not been convicted of anything or sentenced or anything. This is kind of early in the game.
Okay.
All right. So you have Mr. Tamani's number?
Yes. Yes, ma'am.
Okay. All right. You all keep trying to get her family so we can try to work out a plan for her. Okay.
Okay.
All right. Thank you.
Next, we'll go position 12, Mr. Miller.
Okay.
Mr. Tamani, is that one? Did you talk to him, Miller, or is that Bartel?
Yes. Mr. Miller is yes.
All right. This is 25 CR 007346E. Rodney Miller, charge of driving, window tint violation, reckless conduct, and child or youth restraint not used properly. Retrial.
Fifth arrest. Went to felony earlier. 5,000 split was the bond. Got an open theft by receiving, open battery out of Cobb, and a 2014 burglary first offense.
Okay. State.
I'm sorry, Your Honor, what position is this?
12, Miller.
One moment. Ms. Morrison, do you have Miller?
Rodney Miller.
Ms. Morris?
Give me 1 second. Your Honor, can we go to another case while we figure this case out?
Okay. Deputies.
All right, we go to
Position 18, Your Honor.
18.
1-8.
This is 25 CR 007381J. Teclamarium, maybe, and I apologize if I mispronounced your last name. Charge of 1 count of criminal trespass and damage to property. Pre-trial.
Yeah. Second arrest. Got an open case for reckless conduct and littering. It's 25 CR 006778J. That's a pretrial bond too.
Okay.
That's it.
State.
Yes, Your Honor. On November 11th, 2025, Atlanta Police Department Officer Mead, along with Officer Madison, responded to a call at Spectrum on Spring Apartments located at 1270 Spring Street Northwest regarding a resident actively damaging the club room. Upon arrival, leasing consultant Jasmine Gresham reported that a resident, that a resident, Mr. Leonardo Manny, witnessed the defendant pouring coffee and milk on the couches, lounge chairs, coffee table, and floor. She was also damaging a flower pot by digging and throwing soil. Mr. Manny confirmed that he saw the defendant causing the damage. Maintenance estimated the cleaning and detailing cost of approximately $500. After being read her Miranda rights, the defendant admitted to the actions. She had a recent arrest for throwing items off her balcony. Your Honor, we did speak with Jasmine Gresham. She says she knows the defendant because she works at the property. She stated that her and the residents and management think that the defendant may have MH problems. She says she paid the bills on time, but she throws things off her balcony. At some point, she was throwing knives from her balcony into William Street. She has been caught taking packages from other residents from the mailroom, spilling coffee in the common areas. There is an eviction notice. They recently served her a 7-day eviction notice. They just want the defendant to stop her current behavior, respect her fellow residents. The state's recommendation is a $1,000 surety bond, an MHET, and then to comply with any eviction notices, no alcohol, drugs, or weapons while on bond.
All right.
That's all for the state.
Is this your case, Mr. Tamani?
Yes, Judge. Miss Teclamarium is 25. She told me that she's been living in Atlanta for the past year and that she's been in the US since 2021. She's originally from Russia. She told me that she works full-time at Microsoft as a software engineer and that she has a bachelor's degree and a master's degree. Um, I did advise her that it would be likely that there's going to be a no contact order with the address in this case. She understands that. She said she would not go back if ordered not to. We would just ask that she get a signature bond because she told me that she would not be able to post a bond essentially.
Have you been in contact with any family or relatives?
Judge, she told me that she has a brother that lives in Colorado, and she said that her father lives in Russia. But besides that, she doesn't have any contacts.
Do we have an address?
Judge, I was not able to get an address.
So if I order MHET and that 1,000, if I do a signature bond, we probably won't see her again. I don't know. We don't have an address.
Maybe she could provide one. I'm
Can you provide an address?
Do you have an address?
Speak loudly. Yes, ma'am.
Can you put it in the chat, Deputy, or how do you want to do that? Can you put it in the chat, Lewis? Hold on. Can you put that in the chat, Deputy?
Yes, Your Honor, I'm doing it right now.
Thank you.
Your Honor, if I may, she has an open case with us for reckless conduct and littering.
Yes.
Her bond condition for that was a $2,600 signature bond through pretrial social services. Through pretrial services, a social service visit, and an MHET. However, she has not complied with the MHET at all. So the state will be against a signature bond for those reasons.
Okay. Thank you for that update. That's important.
Thank you.
How much was that bond? I didn't even notice.
I think she said 2,600.
So it'll be 2,600 surrender, just so you know.
Right.
That was a bond that was issued on October the 29th by Judge Law.
All right. Well,
You got an SOB through pretrial services, level 3.
Right. I'm going to give her the $1,000 surety bond for today. And see if we can get that MHET done. Order that again. Order her to stay away from the, is it Spectrum Spring Apartments or the incident location?
That's her address. They just put the same address in the.
Oh, it's the same address.
That's where she reside at. That's her apartment.
Yes, Your Honor, I'm sorry. Yes, she's a resident there. The management, it says the management recently served her a 7-day eviction notice.
And then she started damaging the apartment. That the allegation?
I'm not sure.
Well, it said damaging the club room or damaging maybe.
Yeah, but I don't know if the reason that she did it was because of the eviction notice.
Well, that probably won't be her address. So I'm going to keep her here on the surety bond and hope we can get this MHET done. And to comply with any recommended treatment or medication that may be ordered. I'm assuming we don't have any contact with any family. So let's just do that. And I will order her to stay away from there unless she has a valid lease or reason to be at those apartments. Looks like she needs to stay away from there. And no drugs, alcohol, weapons, or guns while on bond.
So I guess my question is that she's to stay away from the leasing place, the clubhouse, because that's where she damaged the stuff at, or she can't go to her apartment at all.
Well, if they're going through with the eviction, and maybe I don't know
Yeah.
when her court date is, she's probably not going to be there. So it's probably going
Yeah,
to be
I got that
granted.
part, but she's going to have to eventually
Get her items.
Yeah, exactly.
I'm following you. So we'll order a one-time law enforcement escort to go back to the location to get any of her belongings. She's to stay away unless she has a valid lease or a reason to be there. Stay away from the whole property, unless her lease somehow gets reinstated. So let's just kind of say it that way. But we definitely want to make sure she gets this MHET and complies with any treatment.
Do y'all want to keep it on the 9 o'clock or the 11 o'clock calendar?
It's up to the state. I don't know that. Does it matter? You tell me.
Are y'all asking for a eval while she's in there? Somebody gonna submit me an order for that? Or
I would like to have it while she's in there.
Well, if I could, Your Honor, can we just clarify the purpose of the evaluation is to get her services, or is it to determine a competency issue? Because I don't think any issues have been raised about competency. It sounds like she just needs
services. I think you're right for services.
Okay, so that would be a reset to an SAP calendar. Okay.
Yes.
Thank you.
All
Thank
right,
you.
Thank you.
Thank you.
So
All right.
worker visit on there too?
Yes. But they may get to it first and be able to determine something. All right. That's it. Nothing else.
We can go to courtroom 1. I think they're ready.
They're ready? Okay.
What position he said?
It should be
Oh, we're going to the interpreter case?
Yes.
What's his name?
It is it's position 10, Lorenzo. Mario Lorenzo.
Yes.
And is this Spanish?
Yes, Your Honor.
All right, raise your right hand for me. Madam Interpreter, do you solemnly affirm that you will faithfully interpret from Spanish to English and English to Spanish the proceedings before the court today in an accurate manner and to the best of your ability with no embellishments?
I do, Your Honor.
All right, thank you. All right, this is position 10, case number 25 CR 007380J, Mario Lorenzo, charged at 1 count of loiter and prowling.
Está bien, estamos conociendo el número 10 en la lista de causas, número de caso 25CR 00738J, Mario Lorenzo, con cargos imputados de vagar y rondar.
Pre-trial.
Servicios previo al juicio.
Third arrest.
Es su tercer arresto.
2022 ag assault amended to battery DV conviction.
2022, agresión con agravantes, enmendado a un cargo de violencia en el hogar, agresión física.
He had a 09 ag assault arrest. That's all.
Tenía un arresto por agresión con agravantes en el 2009, y es todo.
All right, stay.
¿Está bien? ¿Qué dice la fiscalía?
The defendant currently has a $1,000 surety bond.
Actualmente, el acusado tiene una fianza de garantía de $1,000.
The state is okay with converting that to a $1,000 signature bond.
El Estado está bien con que la fianza de seguridad se convierta a una fianza de $1,000 bajo palabra.
In addition, we're asking that he stay away from all quick trips.
Además, estamos solicitando que él se mantenga alejado de toda gasolinera Quick Trip,
which is the subject of this particular arrest.
que es el tema de este arresto en particular.
And we also would ask for a stay away from the incident location,
También estamos solicitando una condición de ningún contacto al lugar del incidente,
which is 761 Sidney Marcus Boulevard,
que sería el 761 de la Sidney Marcus Boulevard
in Atlanta.
en Atlanta.
Nothing further from the state.
Nada adicional de parte del Estado.
All right, Mr. Bartels?
Muy
Yes,
bien,
thank you,
licenciado.
Your Honor. Yeah, thank you, Your Honor, and thank you, Ms. Morris, as well. Judge, we would not oppose the signature bond in this case.
Licenciado Bartels, sí, gracias su señoría y gracias señora Morris. Su señoría, no nos oponemos a la imposición de una fianza bajo palabra en este caso.
We would concur with that and also would not object to a stay away order.
Estamos de acuerdo con eso y también no nos oponemos a una condición de ningún contacto con el lugar.
All right, I will grant that $1,000 signature bond through the jail.
Muy bien, entonces otorgo la fianza bajo palabra de $1,000 a través de la cárcel.
He is to stay away from all QTs in Fulton County.
Que no vaya más a ninguna gasolinera QT en el condado de Fulton.
And he is to stay away from the incident location QT on Sidney Marcus as well.
Y también que se mantenga alejado del lugar del incidente, la gasolinera QT sobre la Sidney Marcus Boulevard también.
No drugs, alcohol, weapons, or guns while on bond.
Nada de consumo de drogas, alcohol o tenencia de armas o pistolas mientras está en libertad bajo fianza.
And I think that's it. Anything else, Mr. Bartels?
Y creo que
Nothing
eso
further.
sería,
Thank you, Judge.
creo que eso sería todo. ¿Algo adicional, licenciado Bartels? Nada, nada, su señoría. Es todo.
All right, I think that's it.
Muy bien.
Yes, thank you,
Creo que es
Judge.
todo.
All right, thank you.
Thank you, Your Honor. May the
Thank you.
interpreter be excused?
Yes, you may. Thank you.
Thank you. You all have a great rest of your week.
Thank you, Ms. Thomas.
You too.
You're welcome.
Judge, can we do Mr. Osteen's case?
Okay.
Add on number 1.
This is 25 CR 007386Y Garrett Osteen, charge of 1 count of possession and use of drug-related objects, pretrial.
How many add-ons do we have?
Oh, they just added 1. You didn't see that?
No.
It was 2. They just sent out another. Well, they didn't just.
Oh, I don't have that history because I don't know nothing about it.
State, do you have the history?
Yes, Your Honor, this is his first cycle.
Okay. First, okay.
Okay.
All right.
While on patrol near 2610 Metropolitan Parkway, APD Officer Mason observed a group of individuals at the corner of Metropolitan Parkway and Connell Avenue Southwest. One individual, later identified as Mr. Garrett Lewis Osteen, was seen holding a glass pipe commonly used to smoke crack cocaine and exhaling white smoke. But noticing the marked patrol vehicle, the defendant turned slightly and discarded the pipe into nearby grass. Officer Mason approached and observed the pipe, consistent with recent use and matching the direction of the defendant's discard. There were no other similar objects nearby. Your Honor, the state's recommendation is a signature bond through pretrial services to stay away from the incident location, no alcohol, drugs, or weapons while on bond.
Y'all know it says NOD and Odyssey for these 2 charges?
So
that's
So
what
we-
I was
told
getting
it
ready
was
to
one
say
charge.
too. That's why I was
Yes.
getting ready to say something too.
yes,
Hold
we
on.
know some of the charges, but we charged
Okay.
one of them. Yes.
Well, they NOD both of them.
Yeah,
There's
they
two
did.
charges on his booking screen for possession, use of drugs and related object, and they said NOD on charge 1 and 2.
Yes, and then we added it again.
Let me check the case. I'll check it just to make sure.
Yeah, I mean, if the state really isn't going to go forward, maybe we could just resolve it today.
Yeah, let me pull his history because there's something on his PSA.
Okay.
Hold on.
Yeah. We were going to go forward with one count of the possession of drug-related objects, but let me check to make sure that it's properly charged within Odyssey.
So I'm saying y'all adding a third charge, so it'd be a total of 3 charges.
No, it's one. So he was booked and charged with 2 counts of possession of drug-related objects. We wanted to NOD one count and charge the other, leaving the other. It looks like that there's an additional charge of, it says it was filed, but it hasn't been filed with the clerk's office. I'm looking in my side, I see a charge of possession of use of drug-related objects. Are you saying you only see 2 charges?
No,
as
I'm just
opposed
saying, yeah, we have the charge because we have it on the counter because we accused it because y'all filed it out, but I'm just letting the jail know that this gonna be 3 charges, 2 of them are NOD and this gonna be an extra charges. That's what it looks like is to me because they said that they receive an NOD for charge 1 and 2, and now this is gonna be 3.
Yeah, I think the confusion is that the 2 charges originally both were NOD, and his jail screen is showing that both were NOD. So I don't think if another charge has been filed, I don't think that new charge is showing on the jail screen yet.
It's not. It's probably gonna show until they get this counter.
So I just don't want the jail to get confused in terms of whether he's
Now,
supposed to
I
release.
sent an email to the jail telling them what happened, but I want to make sure everybody here is clear of what we need to do.
So y'all
Because
dismissed 2 of the charges and refiled 1?
technically, yes.
Okay.
So that's the way to, technically, yes. So one of them just replaced the other one. So it shouldn't be, so I don't want people to be confused and think we dismissed both counts. It's just the way that it was done. Technically, it should have been, one should have just been accused, but we wanted to keep one. So instead of reviving the second count, we just added another one. Yeah.
Which happened to be the same as one of the ones you NOD'd, right?
Correct. Same exact charge, same exact date. So there it should be it's not a total of 3 charges, but the way that it looks in Odyssey it is. But technically it's not. It's reviving one of the NOD charges. I can send an email to jail records to let them know that if that's confusing to everyone.
It probably will be, but I don't know if the email clears it up so much as
It shouldn't be too much confusion because they're gonna go by what's on the counter. So if they're gonna see this counter, they're gonna see it on here. I guess you probably should send them something because I know I'm gonna get questioned about it. The jail's gonna contact me before they contact the
What
solicitor.
position is it on the calendar? Because I don't look at what position is it on the calendar? Is it 3
It's
counts?
it's on the add-on. It's an add-on.
Is it 3 counts on the calendar?
No, just 1.
Yeah, we got a message in the chat from Mr. Jordan. It looks like they've received the corrected NOD letter.
Yeah. So if it's only 1 count on there, they shouldn't be confused.
Yeah, and we would just concur with the signature bond recommendation, Your Honor.
okay. That will do it too. Is this a signature bond? Is this through pretrial or the jail?
Jail is fine. Pretrial is not jealous.
Yeah. Okay. All right. So we'll do a $1,500 signature bond through the jail. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it. Are we, I think it was in the street per se. Do we have a stay away at all or no?
Yes, Your Honor.
Oh, you want to stay
yeah.
away from the incident location?
Yes, Your Honor.
Okay. All right. And I think that'll be it.
Thank you.
Okay. Thank you.
Next is position 21.
This is 25 CR 007378J. Helen Williams Bolston, charged with 1 count of hit and run, duty of a driver to stop in or return to the scene of an accident, driving, striking unattended vehicle, and 3rd count of failure to report striking a fixed object.
So second, simple battery, family violence conviction was all I saw. That's it.
Okay. What year?
You know what? I didn't know that. Let me check.
1995.
Okay, that's why.
95. Okay, right. Thank you.
Yes, Your Honor. On October 16, 2025, City of Atlanta police officer Smith responded to a vehicle accident at 642 Leicester Street Northwest. The victim, James Arpad, a resident of 638 Leicester Street Northwest, reported that his neighbor, the defendant, backed her white pickup truck into his unoccupied parked Dodge Ram and also struck a fence on his property, causing visible damage. A second victim, Stephen Nunez, stated that Ms. Williams Boston also struck the front of his vehicle during the same incident. The officer observed minor damage to both vehicles and the fence, as well as matching damage on the defendant's truck, which was left at the scene. She had departed in another vehicle prior to the officer's arrival. On October 20th, investigator Tacker was assigned to the case. He attempted to make contact, but the defendant became confrontational and refused to cooperate. And on November 4th, investigator Tacker obtained an arrest warrant, and she was arrested yesterday. Your Honor, the state's recommendation is a signature bond through pretrial services on BHET, no driving unless she gets insurance, and no further contact with James Arpard and Stephen Nunez, no alcohol, drugs, or weapons while on bond. The reason that we're asking for not driving unless she gets insurance is because the state spoke with the victim, Mr. Arpad, who stated that he found out that she was uninsured and now he has to pay deductible for his insurance in order to get his car repaired. He stated that the defendant is a nuisance in the neighborhood, and that all the neighbors say that she bothers them. He believes that the defendant may need an MHET.
All right. And I see a James there. Is that the victim?
Yes, Your Honor.
All right. Would you like to briefly address the court?
Yes, I would, Your Honor.
Raise your right hand for me. You affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. Thank you. And state your name for the record.
James Arpad.
Arpad. Okay. All right. And are you in fear of Miss Helen Williams Bolston?
Well, fear is probably not the right word. I believe that she has animosity towards me and may pose somewhat of a threat. She has been abusive and confrontational when I see her, and she has attempted to get other people that she knows involved in confronting me on her behalf. I do not live at the house next door. That was the one thing that was incorrect. It's a rental house that I own. But I have an ongoing trespass case against her for the vehicle that she parks on my property. And so this is what's led to, I believe, what's going on right now.
Okay. All right, I think I get it. So you don't want to have any more contact with her, obviously.
No, I prefer to have some sort of order of protection or something that stops her from approaching me, or I've had real estate agents that have come, and she's said things to them and been abusive to them with clients who are looking at the house. So if there's some way to preclude her from approaching myself or anybody that helps me, that would be awesome.
Okay. All right. Let's hang on for a second and mute yourself. Let me hear from her attorney first. Okay.
Okay.
Okay. All right.
Thank
Go
you,
ahead,
Judge.
Mr. Tamani.
Miss Williams Bolston is 63 years old. She's advised me that she's lived at her address for the past 30 years and that she also worked for MARTA for 30 years, but she's retired now. I believe her last arrest was in 1994. Judge, looking at the booking report, it says that her address is 644 Leicester Street, but she's advised me that her address is actually 642 Leicester Street. So maybe there's some sort of typo there or something. But we did want to just inform the court that her address is 642 Leicester Street. Um, we would not object to a signature bond in this case either, Judge.
Okay. All right. I guess the problem is, James, how close is your home to her home? They're
It's
not next
about,
door.
they're completely next door. There's
Oh.
about 7 feet that separate the two houses.
Mm-hmm.
And the problem that has arisen in the last year is that she is claiming that somehow the city gave her ownership of my property verbally before I bought the house. There's a driveway between the two that's about 7 feet wide. So she insists on parking this unregistered, unlicensed vehicle there, and has broken down the fence that I've built to separate our properties, and is pretty much irrational about it. I've had a survey done. She's been provided the survey by my attorneys. She insists that her property rights are that the city has given her my property, and I can go to hell, in other words.
So is there other civil litigation filed over this?
I believe it's in process of being filed. She's been served with papers that have asked her to stop her trespass. And I believe next week is when the actual case is being filed with the Superior Court.
Okay. Well, I hope you get to the bottom of it with not much more criminal intervention, but
Me too, Your Honor. Thank you.
I'll do the best I can here. It's only her second arrest. The other one was old in 95. I'll grant her a signature bond as long as Ms. Williams Bolston, you can tell me that you're going to not harass James. And it sounds like until you all get this sorted out, that maybe you shouldn't be parking in that adjacent driveway. And will that maybe help you all to halfway get through this process by me giving her a. So let me ask this, the fence that she's alleged to have hit or something, is that on your property, James?
Yes.
Oh,
While
okay.
she had moved her pickup truck, I had a fence erected to define where my property ended and hers began. And the big problem that I have is there's a door, a steel door leading to the crawl space of the house that is right where she keeps parking her pickup truck. So I've been unable to do any kind of repairs or maintenance underneath my house because she refused to move this pickup truck. So one day I was luckily passing by because I'm in the neighborhood every day, and I saw that the truck was gone. So we quickly built this fence to protect access to the lower level of my house, the crawl space door. And when she came back, first she backed her truck into my truck. Then she turned around and drove into the fence and broke down the fence. And all the pictures of this are enclosed in the police report that rather Officer Smith filed. And then when Mr. Nunez drove up, she drove into his truck to stop him from coming up the street. After that, she tried to get several people who live on the block to attack us to say it was our fault that she did this, and then drove away in another vehicle that she owns that I believe is not insured either, and did not stay for the police to come and file the report, which is why it became a hit and run. But if she was to move her pickup truck, which is illegally there, it hasn't been licensed in 2 years, that would resolve so much of the problems and allow us to move forward with my selling the house and never dealing with her again.
Okay. So I will order, and let's see, with the hit and run, that's $1,000. Driving, striking an unattended vehicle, 500, and failing to report, striking a fixed object, 500. So that'll be a $2,000 signature bond.
Level 1, you good?
Yeah,
Oh,
level 1 through pretrial level 1. I'm going to order the defendant to, she can still park her car, I'm assuming, on the street in front of her house.
Oh, absolutely. Yes. In fact, I think code enforcement had already talked with her, cited her for having, there's another car as well that she parks on the sidewalk that has been unregistered and uninsured for like 4 or 5 years. So I believe they've offered her, or rather ordered her to move the vehicles, but I don't know the status of that.
Because I'm making sure if I say in the interim that she not park in this adjacent driveway, that she have sufficient, ingress, egress, or sufficient way to get on and off her property by parking on the street till you all can get this driveway situation resolved.
Yes, Your Honor, absolutely.
Okay. And so do you understand that, Ms. Williams Bolston? Are you going to be able to do that? Can you hear me?
Yes, ma'am, I do hear you. May I address just a mention, please?
Okay, and tell me why.
The reason why is that, and I was told not to get too deep, so I'm just going to try to be simple. The situation that Mr. Arpad and Mr. The other gentleman is describing to you is completely misleading, and that everything that he's shared with you is not correct, and I can tell you why.
Yeah, it's just that this is not an evidentiary hearing. This is just for bond. So I'm trying to kind of, if I can, make the peace for a moment until we can, you all rather can get into court further. And in the interim, If this driveway is the bone of contention with you all,
Oh, okay, I understand.
I was making sure you could get on and off your property without parking in this driveway that he claims is on his side. He'll have to prove all that. But in the meantime, I want to know if you can stop using it to get on and off your property.
Unfortunately, no, ma'am, I won't be able to. And reason being, Mr. Arpad is really trying to steal property, and this truck, what he's talking about, our property line is right in the middle, and he's trying to place me within his scope of work that he's doing in his house, which allows him to encroach on my property. Everything that he's saying to you, he has encroached upon me. There has not been any fence erected on the property other than the fact when I went to breakfast, he built something really quick in 30 minutes where I've normally been parking for 30 years. Not 1 year, 2 years, 30 years. I have proof that I own this situation, but he's a very powerful, got plenty of money, and I'm unable to fight him because I am a legacy resident, and I'm only under $1,800 a month, and he knows it. So yes, we are going to court. Yes, I am going to do a civil suit against this man because now I am just completely thrown by his remarks. So to answer the question, the parking, my truck will be there until we go through court because he's already placed his survey way beyond the encroachment spot. So therefore, my vehicle will be there until after we go to court, which is on the 1st.
Oh, you all go to court on December 1st?
As far as I know, yes, ma'am, and that's why I was detained yesterday. I was supposed to be in court, family court, to take a TPO out on him because he has been harassing me, but the police intervened and put this warrant in front of me, and I couldn't make the court date yesterday at 2 o'clock. So now I'm in this situation, which he pushed forward with the officer coming to my house and bullying me about James Arpad himself.
Okay, so with this adjacent driveway that goes in between both properties, what's the suggestion as to what I do, or else we're gonna have them back in same situation? State or Mr. Tremonti, what do you all think?
Your Honor, the state has asked, I did put it in, if we could just order no contact with the victim. It seems to be a dispute as to who the driveway actually belongs to. That's something we cannot resolve today or even have jurisdiction to resolve. So we would just ask that the signature bond be put in place and no contact order. I think that resolves or addresses the issue before this court today.
And I would agree with that.
May I
Well,
say
if we think they're
further?
able to not have any contact, we'll see what goes there.
Your Honor, may I speak?
Yeah. Yes.
Thank you. I do believe, that everything that has been said is completely inaccurate. There is another person, Steve Nunez, who was a witness to everything. And I think I understand this is a bond hearing, but yeah, the vehicle is unregistered and unlicensed, and that is a city, county, and state violation. And I don't know if you have any import onto that situation, but that is against the law for a vehicle to be on city property, whether it's on your own personal property or on somebody else's property. That is illegal.
And so is it still there now or has it been moved?
As far as I know, it's still there, Your Honor. It was there 2 days ago, the last time I was drove down that street.
And it's parked so that, is there someone in the house next door that lives there, or you don't, or it's not occupied?
Right now, it's not occupied.
Oh.
The tenant had moved out, and I would need to do work on it to be able to sell it or rent it. But I cannot get into the vehicle pulls up within 6 inches of of the house and blocks me getting into this steel door access to my basement, to my crawl space. So I am unable to do work that I need to do on my own house. I can't rent it. I can't sell it.
Because her truck is still parked there.
Correct.
What are you going ready to say, Ms. Morris? Help me out.
This needs to be addressed in civil court. We can't address this. We have no remedy. We don't have any facts. We don't have any issues. We've heard what the concern is for Mr. James, but this is not our purview. And I don't think we have a lot of cases. It's not that this is not important, but we have a lot of people waiting to be heard. And I don't think we can resolve this. We don't even have the information to address it.
I
understand. The problem is that the criminal charge of hit and run is hitting, and I'm not for sure about hitting what she hit and ran from, driving, striking an unattended vehicle, failing to report it. So did she strike a vehicle of yours, or whose vehicle?
She hit my pickup truck, and then she, but I was not in it. I was outside on on the sidewalk. But then she did run into Mr. Nunez's pickup truck, and he was driving it. He was in it.
Okay.
Yes, Your Honor. So the hit and run is for striking Mr. Nunez's car. He was driving it at the time. For Mr. Arpad, his vehicle was unattended. That's the other charge. And then for striking the fence as well. Yeah.
Okay. And now I'm clear. So we have those charges, which, you know, I agree they're still coming from a civil incident, property dispute incident. And now we have these charges, which are criminal in nature, but they still are arising from this civil property dispute.
Yes, Your Honor. So the state is asking for the signature bond, not driving unless she gets insurance, no further contact with Mr. James Arpad and Steven Nunez, to stay away from the incident location, 638 Leicester Street Northwest. No alcohol, drugs, or weapons while on bond. The state recommended a BHET based on what we heard from the victim, but we can defer to the court if you think that the BHET is appropriate.
If I order the stay away, and I would definitely, because these parties certainly need to do something in the interim to resolve it, are they going to be able to stay away if her car is there, can't be moved because it has no insurance? And I just don't see that we're resolving anything with the stay away.
I would say that it's Miss, I forget her name. I'm so sorry. The defendant's is not to have contact with him. I mean, but we can't order her if this is her property and we're going to tell her to get off of her we don't know. That's why I said I don't think we can. We don't know whose property it is. We don't know who's telling the truth. We don't know what the survey says.
Right. This is an adjacent driveway that goes between the two properties.
They may both.
And then, yeah, at this point, the line is somewhere in between. And so what I'm getting at is they're going to be right back here if she's not going to move her truck. If the truck is still there and it can't be moved because it has no insurance, and he needs to get on and off his property as well.
So maybe we say they have no contact directly. So, I mean, if they are no contact directly, so they should not talk to each other. They should not engage with one another. They should not be in each other's presence. But if she parks her car and he happens to be on the other side, she needs to go about her business. She does not need to engage him. She does not need to interact with him. She needs to go as far as possible. And so I know she can hear what I'm saying, but I think that's all we can do at this particular time.
So
all right.
Sorry. Yeah. May I say something?
Quickly.
One more thing. Yes. Because the vehicle is uninsured and unlicensed.
That's not before the court today.
The court has no leeway to say she was driving this vehicle illegally. That is criminal. Can the vehicle be required to be removed from her possession?
Oh, no, I can't. I mean, removed from her possession. What do you mean? We're not going to confiscate the vehicle.
Off the premises because it's violating state law.
I can't do that. I don't know because I don't know that it is technically. And I think ASG Mars is with me. I don't know that it is illegally on her side or your side. You know, that part I couldn't tell you.
Well, no,
Certainly
that
she's supposed to
right.
have it insured to drive it. So if she keeps driving it uninsured, I guess you call police and say pick her up again for driving without insurance. I mean, that will take care of itself. But if she's hitting your vehicle and the other vehicle or hitting the fence, those are things that she can be ordered not to do or to pay for the damages resulting therefrom. I just think that for me to order her to move her vehicle from the adjacent driveway until it's determined that she's violated something by parking it there, I don't know
No,
that I
that
can.
wasn't what I meant, Your Honor. I
Okay.
apologize. I meant because it's an unlicensed, unregistered vehicle.
Well, she's
City
already.
state law says it cannot be on any residential property.
I don't know that the law says because it has no insurance. Is it no? Because she's not even
No
charged with that.
registration.
No registration. She's not even charged with that.
I don't
You
know
know, it
why not.
wasn't like she was
Yeah.
driving it down the street and got pulled over when they ran the tag to saw that it was expired. That's not what the charge is.
Okay. So that
Correct,
charge was not
ASG Mars?
included?
Can we,
Because
No,
yes.
she's
Well, that's
not
not
charged
before
with
the
that.
court. Can we
Right.
move on?
Yeah,
Just
she's not charged with that. So
okay,
all
because
I'm going to order is that's not what the charges are. And I
I
read them:
understand.
hit and run, driving, striking unattended vehicle, and failure to report striking a fixed object. So
Okay.
I'm just going to order again that she stay away from your property, wherever that may be, that she have no further contact with you. The two of you should have no further contact. She shouldn't have any contact with you.
Which is good.
I think as ASG Morris said, not talk to you, not have any interaction, however that needs to go.
I'm so sorry. Is there any way, because she did try to bring other people into what she called defending her against myself, and she's been giving petitions in the neighborhood for people to basically attack me. And I think that inciting people to attack me would be something I'd love to be protected by.
Then you
Mr.
need to
James,
speak
do you
to
have our witness
police.
advocate number? Because we
Yeah.
can call you later. Do you have,
Thank you.
you spoke to witness advocate, right? So
They
you
can
can
speak
call
with you.
contact them, let them know what your concerns are, and we can address the court. We can bring them to the court if we feel they're valid. But right now, the judge has made a decision as what she wants to do with this case. We welcome to hear any other concerns you may have. Please give our victim advocate a call. I think that's Ms. Calloway who you spoke to today. Let her know what your concerns are, and we will address them with the court at a later date.
Will do. Thank you very much.
Thank you, ASG Mars. And that was a 2,000 signature bond through pretrial.
Level
one. Yes,
and,
level 1.
And the conditions is no further contact with the victims and stay away from the property of 638. And then you put no driving unless obtain adequate insurance or registration on the vehicle owned by the own or drive. And no
I
drugs.
guess I can throw that in, even though that's not before the
Well,
court.
no drugs, or alcohol, weapons, or firearm. I just want to make sure I got the order right.
Yeah, I'll throw it in for what it's worth, but I'm wondering if I should even take that out because she knows how to follow the law with that, but she needs to really get charged with it before I tell her
I'll
that.
always put it in there regardless. She does.
Yeah, we'll throw it in. We'll throw in that because I guess she could be arrested for it if she doesn't get the truck properly insured and tagged.
And that's
registered.
it. And
Yep,
nothing
that's
else.
it.
I just want to make sure. And there's nothing else about the parking.
No, I'm not going to address that.
Okay. All right. I just want to make sure I got the orders correct. That's all.
No. So ASG Mars will be representing me. I tell you, of taking me further into it. And Mr. James, maybe you need to consult an attorney.
Oh, my attorney is filing the case next week. Everything is.
Oh, well, good. Then you guys will be over in the civil court to hopefully.
We will be
set it out.
there. Yes.
Great.
Thank you, Your Honor.
All right. Good luck to you.
Appreciate you.
All right. Thank you.
Thanks.
All
Bye-bye.
right. Bye-bye. Who do we have next? Are we still at ACDC or no? Oh.
I just have one more left. Miss
Yes.
Trailer, position 19.
Okay.
Come on.
25 CR 007365G Rochelle trailer charged with 6 charges. Obscured and missing license plate. Failure to have license on person. Driving while license suspended or revoked. Reckless driving. DUI and possession of open alcohol container. All right. Pre-trial.
39. I gotta open. Oh, hold on. It might have get. It might be the same stuff. All right, I got 2019 ag stalking conviction, 2019 fade to appear, 2020 ag assault DUI, interference with government property, felony obstruction, hit and run, fleeing an officer, driving without a valid license. That's one arrest. They all were convictions.
Okay.
On probation. Hold on, they got this in all caps. Okay, on probation for all that stuff I just gave you. 2021, they gave him 3 years prison, 9 years probation. That's it.
Okay. State.
Yes, Your Honor. The incident date is November 7th, 2025. APD officer Verna and Urina conducted a traffic stop at Hamilton E. Holmes and Donald Lee Holloway Parkway for displaying an improper tag. The driver identified herself as Kathy Rose Taylor, but she did not have a license on her. She admitted to drinking. Her eyes appear glossy. She agreed to perform field sobriety test. Officer Bolanos conducted the HGN test, which showed 4 out of 6 clues. She then declined further testing. A vehicle inventory revealed a cold open 16-ounce 10-ball malt beverage containing 10% alcohol content in the front console and a crack pipe in the rear passenger door. Once at the jail, they could not find her. On the record, further investigation through Axon revealed that her true identity was Rochelle Taylor. She did not have a driver's license due to a DUI suspension, which was effective on June 22, 2021. Your Honor, based on her criminal history, she does have a 2009 giving false information to law enforcement. That 2021 DUI, the state's recommendation is a $3,000 surety bond. That's $1,000 for the DUI, $1,000 for the reckless driving, $250 for the other 4 charges, no driving without a license, no alcohol, drugs, or weapons while on bond.
All right. PD Tamani.
Thank you, Judge. Miss Trailer is 45 years old. She's a lifelong resident of the Atlanta area. She has 2 children, 19 and 13 years old. Both live with her. She said that currently her 75-year-old mother is taking care of a 13-year-old. She isn't working right now. She told me that she was shot in the lower back in 2023, and she's waiting on her disability to get improved. And she does have regular doctor's appointments associated with that injury. Judge, we would just be asking you to take that into consideration when setting her bond, and we would just ask for a reasonable bond.
All right. I'm going to order the $3,000 surety bond and $250 on the first 3 charges, $1,000 on the reckless, $1,000 on the DUI, and $250 on the last charge with possession of the open container. No drugs, alcohol, weapons, or guns while on bond. No driving while on bond. And I guess that's it. Anything else?
No,
Probably
Your
not.
Honor, that is all for the state.
Yes. All right, that's it. Thank you. Have a good weekend.
Position 14, Your Honor.
This is 25 CR 007388B. Sylvanus Newton, charged with 1 count of battery family violence. Retrial.
What we got here? Hold on, sir. Hold on. 25 total. We got FTAs from 2017, 2016, 2014, simple assault conviction, 2013, terrorist threats conviction. All right.
Okay.
Yes, Your Honor. On Friday, November 14th, 2025, Officer Fu of the Union City Police Department responded to a call at 6295 Littleton Drive, Union City, Georgia. Upon arrival, he met with the victim, Claire Riggins. She was inside a Grady EMS unit. She reported that that her and the defendant had a verbal dispute. The defendant is her long-term tenant. The dispute was over TV remote. She explained that she threw his laptop on the ground. She also hit the hat off his head. Mr. Newton, in response, pushed her down, got on top of her, pulled her arm, causing her arm to break or dislocate, according to EMS. The defendant arrived on scene shortly after. He admitted to hiding the remote, but denied any physical contact with Riggins. However, based on the victim's statements and EMS medical findings, the officer placed the defendant under arrest. Your Honor, based on the severity of the injury, he has a 2019 battery family violence conviction. Is with a different victim. The state requested that this case be transferred to the DA's office. We're just waiting to hear back from them. But the state's recommendation is a $7,000 cash bond, no further contact with Claire Riggins, stay away from 6295 Littleton Drive, Union City, no alcohol, drugs, or weapons while on bond.
All right. Mr. Tamani.
Thank you, Judge. Mr. Newton is 48 years old. He's been living in Union City for the past 9 years. He did advise me that the alleged victim in this case is his landlord, and that he rents the property from her. He said that he has 2 children that are 15 and 11 years old. He said that he is the primary breadwinner and for providing for them. He has a bachelor's degree. He told me that he works at State Industrial Products as a strategic account manager. He told me that if he's not able to make it to work on Monday, he will lose his job. We would just be asking Your Honor to set a reasonable bond.
I am concerned about the allegations. And I know it's pending a transfer. We just don't have the transfer yet. Let me, and the previous cases with the same victim, correct or no?
No, Your Honor. The 2019 battery family violence was with a different victim. He also has a 2014 simple assault in the cab, 2013 willful obstruction, terroristic threats and acts in Cobb County, several FTAs, probation violation from 2011, 2014, 2015. Yes. Yeah, Your Honor. So definitely a lot of FTAs, a lot of probation violations, and several violent convictions.
Right. Okay, I'm going to order a $4,000 cash bond and stay away from the victim in this case, Claire, and I didn't write the last name down. No further contact with this victim. Stay away from the incident location. And no drugs, alcohol, weapons, or guns while on bond.
Can the state clarify the stay away,
Hmm.
please? Can the state clarify the stay away address again, please?
Oh,
Yes,
stay away.
absolutely. It is 6295 Littleton Drive, Union City.
Thank you.
Thank you.
All right, nothing further. Mr. Tamani, your client is raising his hand, but I'm sure you're going to tell him to put it down.
Mr. Newton, if it's anything about like the incident or what happened, it's best probably just to hold off on it. Like this is just a bond hearing.
Well, not necessarily. I was just gonna say that just based off the incident report that she read, as far as like, I'm not gonna go into that, but I am the primary breadwinner of two teenage kids, and I know I don't have the ability to make that bond. And if I'm not at work Monday, I will lose my job, and it's gonna put me in dire straits. I don't have to be around her whatsoever. I just don't have any way of making that bond, and I would lose everything. I mean, I would lose everything.
This is based on your history, and I don't know what's going to happen Monday. Do you have somewhere else to go live? Are you going to go back around this victim? This victim needs to be protected from you.
No, I won't. No, I won't, ma'am. No, ma'am. I have a wonderful job in my field, of study. That I mean, it's really a wonderful job, and I just don't want to lose it and not be able to take care of my kids. I would not go around her whatsoever.
Let's say you state.
Your Honor, the state is against anything other than a cash bond based on the severity of the injury to the victim, and based on the criminal history.
All right. Well, you'll be reviewed in a couple of weeks, but I'll leave it at the $4,000 cash bond for now. All right. Thank you.
Hey, Judge, can we go back to position 9, Lester? You want to hear his condition that you gave him again? Have a seat.
9. Let's
Yes.
see. And what's the question?
You want to know what's his condition before he signed a pretrial order?
What are his conditions?
Yes.
Yeah, you had no further violent contact with his wife. He has to stay away from the property until Monday, November the 17th. He can return back at 5:00 p.m. He has to do 2 days of anger awareness classes and submit to an alcohol drug evaluation and treatment, undergoing treatment if deemed necessary.
Yeah, that's what I have.
All right, thank you very much. I just wanted to confirm. I appreciate it.
Okay, you're welcome.
We have position 17 next.
Okay. This is 25 CR 007385B, Quintavious Seals, charge of 1 count of battery, family violence, and 1 count of simple battery. Retrial.
11. He got a possession of a firearm by a convicted felon. Possession of marijuana case. It's 24 SC 006476. Open. 2023 FTA 2017 stalking criminal attempt to commit a felony conviction. I got a 2016, 15, and 13 possession firearm by convicted felon conviction. 2012 theft by receiving conviction and 09 robbery. Criminal attempt to commit a felony first offender. That's it.
All right, state.
Yes, Your Honor. Just want to confirm this is position 17.
Yes.
Thank you. On November 13, 2025, APD Officer Brooks was dispatched to 3006 Delmar Lane, apartment K6, in reference to an assault with injuries. Upon arrival, the officer spoke with the victim, Ms. Michelle Jones. She stated that after ending a phone call with her son, She told Mr. Seals, who had just moved back in, that he needed to find a job. He became aggressive, yelling and cursing at her. When Ms. Jones asked him to leave, he bit her on the right cheek, leaving a visible superficial injury and blood. As she attempted to leave the location, he pushed her into a neighbor's door across the hall. A neighbor confirmed hearing the altercation and described Mr. Seals as the primary aggressor. They declined to provide further details. It was confirmed that Ms. Jones and Mr. Seals have been in an on and off relationship for the past 4 years, and they have lived together on and off for the past 2 years. We did speak with the victim. She stated that she's very scared of the defendant. She wants the defendant to stay away, have no contact. She said the defendant had some sort of mental breakdown. During that evening, he kept calling another woman's name who's already deceased. She said he bit her in her right eye and her eyes closed and black. She says she's seeking a TPO on the defendant. Your Honor, based on the criminal history, the FTAs, the 2019 stalking conviction, the state's recommendation is a $5,000 surety bond, $4,000 on the battery, $1,000 on the simple battery. No further contact with Michia Jones and stay away from the incident location. No alcohol, drugs, or weapons while on bond.
All right. Mr. Tamani?
Thank you, Judge. Mr. Seals is 34 years old. He's a lifelong resident of the Atlanta area. He has 4 children that are 18, 16, 3, and 4. He told me that he does temp work. He has his GED. Judge, we would just be asking for a reasonable bond for Mr. Seals.
And he's how old again?
34, Judge.
All right, I will give a $5,000 surety bond, $4,000 on the battery, $1,000 on the simple battery, for a total of $5,000. No further contact with the victim, Michelle Jones. Stay away from the incident location. No drugs, alcohol, weapons, or guns while on bond. That should be it.
Can you clarify the stay away address? I'm sorry.
Oh, the address?
Yes, absolutely. This is position 17, yeah. It is 3006 Delmar, Delmar Lane, apartment K6.
Thank you.
All right, next.
We have position 20, Mr. Elkins.
This is 25 CR 0073779A. Bernard Utkins, charged with 1 count of criminal trespass.
Yes, Your Honor. On November 13, 2025,
Trial.
Oh, I'm sorry.
You could have went, okay. 6 total on probation. Fair evasion trespass, 25 CR 006-651A. They just got put on probation for that November the 6th. That was the last Thursday. On probation battery DV 23 CR 007-654J. Got an open trespass out of the cab, trespass and obstruction, and a 2025 failure to appear. That's it.
All right.
Yes, Your Honor. On November 13, 2025, While patrolling Garnett Station, MARTA PD Officer Johnson observed the defendant bypass the fare gates without paying. Officer Johnson issued multiple verbal commands for him to return and exit the station, which he ignored. Once the officer made contact with the defendant on the platform, while he was waiting on the train, the officer requested identification, and the records check revealed multiple MARTA suspensions, a 365-day suspension issued on August 9th, 2025, a 60-day suspension on September 7th, 2025, and a permanent ban effective October 23rd, 2025, prohibiting him from using MARTA services or being on any MARTA property. Your Honor, he does have a 2025 fare evasion conviction in criminal trespass, which is also MARTA. During that conviction, his bond was $30 cash bond. And while he was out on bond, this incident occurred. Based on that, the state is asking for a $1,000 surety bond to stay away from all MARTA property, no alcohol, drugs, or weapons while on bond.
All right.
Thank you,
Tamani?
Judge. Mr. Upkins is 25 years old. He's a lifelong resident of the Atlanta area. He told me didn't have a lot of time to speak with him, but he did tell me that he would not be able to make a bond. But that's what we would just be asking for a signature bond in this case, Judge, based on that.
I'm going to still order the $1,000 surety bond. Stay away from MARTA. He already has a ban. No use of MARTA, no drugs, alcohol, weapons, or guns while on bond. Anything else?
No, Your Honor. Nothing from the state.
Okay. Next.
We have position 2, Ms. Gordon.
Okay. $25 CR 0073770D Ashley Gordon, charge of 1 count of disorderly conduct. Retrial.
2018 failure to appear. 2013 theft of services, possession of cocaine with intent. That's it.
Okay.
Your Honor, this Ms. Gordon already has a 1K surety bond. The state agrees this is the appropriate bond for this particular case, based on the history, which includes arrest for simple battery as well as battery family violence. This case involves Ms. Gordon throwing her shoe at a police officer, doing a verbal dispute in which the officer was trying to subdue other people. So based on that, the state would ask that this current bond remains in place.
Yes, Your Honor. I've spoken with Ms. Gordon. She's indicated to me that her bond has already been posted. Is there a way to verify that?
I don't know. We just would ask someone at the jail. I mean, they would be the first to know if it's been posted or not.
Right. Well, she indicates that it's already been posted. So in that event, we would just ask the bond remain the same.
Okay, that's fine.
Thank you.
1,000 surety. When it all catches up, they'll get the information. Next.
We have position 6, Ms. Jones.
$25 CR 0073774A Danielle Jones, 1 count of theft by taking, pretrial.
15. Last arrest was, oh, this the one. Yeah, last arrest was on the 12th. When was that? Wednesday. For petty theft out of California. I seen 7 theft-related arrests this year alone. Finished homes. That's it.
Okay.
She has a 1K surety bond. The state is fine with converting that to a signature bond for $1,000. We just ask that she stay away from Cami Cakes, CAMICAKES, as well as Lenox Mall, which is located at 3393 Peachtree Road. She took $5 out of a tip jar at Cami Cakes, and we're just asking for that bond to be converted to a signature bond.
And we would concur with that recommendation, Your Honor.
All right, $1,000 signature bond. Is this through the jail?
Yes.
Okay. And she's to stay away from, is it Cami Cakes at Lenox Mall?
Cami Cakes and Lenox Mall.
Oh, both. Okay. Cami Cakes and the whole Lenox Mall.
Yes.
All right. And no drugs, alcohol, weapons, or guns while on bond. And that's
Okay.
it.
All right. Thank you, everybody.
Mm-hmm.
We have position 4, Ms. Jackson.
$25 CR 007372E, State versus Miracle Jackson, 1 count of battery, family violence, 2nd count of cruelty to children in the 3rd degree.
First.
Okay. State.
Your Honor, the state is asking that she receive a $3,000 signature bond. As stated, this is her first arrest ever. $2,000 for the battery, family violence, and $1,000 on the cruelty to children. Did talk to the victim in this case. It is a Joshua Lowe. Traditional spelling of Joshua, and Lowe is spelled Lowe. He is the father of her child. This incident happened when she was dropping the child off. A verbal altercation or incident escalated to physical. We did speak to the victim. He wants to continue to talk with the defendant and wants a third party present, or have a third party for drop-offs, for visitations for the child. We do ask for no future violent contact with Joshua Lowe, and then have that third party to facilitate visitation between the parties.
Okay.
And it looks like Mr. Lowe is on the line. I'm not sure if he wants to speak with the court or not.
I was trying to see what did the
Mr. Lowe, Mr. Lowe, Mr. Lowe.
Yes,
Can't
ma'am.
see you, so you can't speak.
Oh, yes,
Turn on
ma'am.
the camera. And this is a bond hearing. So do you have a problem with the bond as been stated?
Yeah, I was trying to see where did the cruelty to the children, like from the
That's not the question for you. That's the charge.
Oh, okay.
So we'll keep moving. She has a $3,000 signature bond through the jail, and she's to
That's
have no further.
pretrial. That's
I'm sorry,
DV. Yeah.
pretrial.
Level
Pretrial
1.
at level 1. All right. Pretrial at level 1. I'm going to ask her to take a 2-day anger awareness course through pretrial. That's $2,000 on the battery, $1,000 on the cruelty. She's to have no further violent contact with you. And if you all are doing visitation, that must be facilitated by a third party so that you all won't have that contact. So find a neutral third party that can help facilitate your visitation.
Okay.
Okay.
No, stay away, Judge.
Yes, ma'am.
Oh, stay away. Well, I don't know. Is there stay? I don't think state said a stay.
Nah, it's not no stay away.
No. I'm not asking you, Mr. Lowe.
Oh.
I mean, we
ASG
can
Morris.
stay away. They don't live together, but we can do a stay away from 490 Glen Street. Glen has 2 ends, and that's in Atlanta.
Well, I'm told, Your Honor, by Ms. Jackson, that they live on separate floors. Of the same building. Is that correct, Mr. Lowe?
You're on mute. We can't hear you, Mr. Lowe. You're on mute now.
Bro, I think that's
I'm on the upper side than her.
I didn't hear you say that again.
I said, yeah, I'm on the totally upper side than her.
yeah, they live in the same building, but not the same floor. So I think a no further contact or no further violent contact without the stay away would work.
The state
A
has no.
third party.
Okay. All right, we'll just do it that way. There will be no stay away, but please find a neutral third party to facilitate your visitation so that you all will work things out, okay?
Okay, thank you.
All right. Thank you.
And Your Honor, I have an announcement on number 2, Mr. Baisden. Whenever the court's ready to hear that, he has waived his presence.
Okay. I think we're down to how many left?
I'm sorry, he's number 1, Your Honor.
We just got waivers left now, right?
I was gonna say, are we all waivers or one more left in the courtroom or?
We have position 12. We was trying to see, are we going?
Oh, that,
It's ready.
state, ready, state, okay. We'll do 12 and then we'll go to the waivers.
I already did the history, right?
Rodney Miller, yeah, I have 5
Okay.
and open felonies and things of that. Okay. 25 CR 007346E, Rodney Miller. Window tint, reckless conduct, and child restraint.
State is asking for a $3,000 surety bond on this case with a breakdown of $500 on the tent violation and the child restraint for each of those, and $2,000 on the reckless conduct. That is based on his history, which includes an open theft by receiving, an open battery case in our office. He also has a pending felony pre-indicted case under 25 PI 009350. That involves the contents of this case. In this case, he was stopped for a tent violation when officers made the stop. They saw that the infant was unrestrained, standing in the lap of the passenger. They also saw an unsecured firearm inside the vehicle, noticed and smelled an odor of marijuana coming from the car. Thus, they were able to, thus necessitated the charges before the court. Based on that and his history, we're asking for that $3,000 surety bond.
Okay. Mr. Tamani?
Thank you, Your Honor. Mr. Miller is 33 years old. He's a lifelong resident of the Atlanta area. His family lives in Atlanta, and they're going to post his bond. He has his high school diploma and a bachelor's degree from Kennesaw State University. And he's currently not working, but he's in the rehiring process with a previous company that he had worked for. So, Judge, we would just be asking for a reasonable bond.
All right. We're going to, I'll order the $3,000 surety bond, 500 on the window tint, 2,000 on the reckless, 500 on the child restraint for a total of 3,000. No drugs, alcohol, weapons or guns while on bond. And that's it. Is there a question about the bond conditions?
Yes, ma'am. I just have a question. I have a statement in regards to my bond, and I just wanted to make sure that it was heard. May I speak, ma'am?
I don't know. Your attorney may or may not. It depends on what you're going to speak about.
Mr. Miller, I would just, if it's about, what we were talking about related to bond, sure. But if it's anything at all about the case or the facts of the case or the incident, I would avoid talking about it.
Perfect. I just want to clarify that it's stated that I have an open case for it was stated that I have an open case for theft by receiving stolen property here in Atlanta, and that case was dismissed recently. And so I just didn't want that to be held against me when it comes down to my bond amount, that case was dismissed a couple of weeks ago.
You have low bonds, but it's your other higher charges and your other, I think there's open case in Cobb as well. ASG Morris.
He has an open, he misunderstood. His open case is possession of a firearm. So it's from this case. It's not the theft by, he hasn't, theft by taking is in another, the theft by taking or receiving is another, but his open felony case is here in Atlanta.
I want to
Either you have a bond, your family's gonna pay
Yes.
your bond. So
Thank you.
yes, you have a bond.
All right, we'll keep it moving. Thank you. That's the last one, I think. Is that it, deputies?
Yes, ma'am, that's it.
Okay, so let's go back to the waiver. Let's see. To position one.
Yes, Your Honor. I did speak with Mr. Baisden. He is in the POU, that's the medical observation unit. He was able to discuss his case with me, and I think, he may be having some mental health issues, but I think he does understand what's going on and what he's charged with. He was able to talk to me about the circumstances of his arrest, and he said he would waive his presence. So we would ask that it be reset. It could either go to SAP. I don't think there's a need for it to go to the 11 a.m. calendar, but he's already got a $1,500 bond. He indicated that there is not anybody available to bail him out. So we would ask if he qualified for a signature bond for that, or if he doesn't, we would ask the bond remain the same.
Well, I'll call this one 25 CR 007353F Enoch Baisden. Let me just hear from pretrial what his history is.
59.
59.
Correct.
Okay.
Got an open disorderly out of Clayton County. Open criminal damage, second degree, DeKalb. Open forgery, first degree, DeKalb. Forgery, third degree, Paulding County. On probation in Fulton, theft by receiving, fleeing an officer. It's 23 SC 191715.
Do you know when that plea was entered, Mr. Howard?
August 2024.
This year?
They gave him 8. No,
Okay.
I'm sorry. August 24th, 2024. They gave him 8 years probation.
Okay.
20. You want more? Anybody?
No.
Okay.
Yes, Your Honor. On November 12th, 2025, officers observed the defendant walking in the middle of Washington Street, pointing a multi-use tool at the victim, Mr. Akron Wallace, to resemble shooting a gun. Also, defendant was observed on recorded video threatening Mr. Wallace multiple times, holding said multi-tool in a manner of holding a firearm. Defendant did advise that he has not taken his medicine in about 6 days. We spoke with the victim. He did not want to comment on the case. Based on, he has a 2002 terroristic threats and acts conviction, and another one from 2013, 2003 aggravated robbery, 2012 battery, several FTAs. The state's recommendation is a $1,500 surety bond, and to stay away from the incident location or Mr. Wallace, no alcohol, drugs, or weapons while on bond.
All right. PD Bartels, I'll tend to just leave it at the $1,500 preset bond unless you want to raise anything else.
Nothing further, Your Honor. Like as I indicated, he said no one is available to bail him. And we would just ask it to be reset to the next, that would be the 4th December 4th.
Is that
That's
correct, Ms. Lewis?
That's correct. That's correct, Mr. Bartell.
Okay.
Okay.
Do you
All right,
want it
thank you.
set to the regular counter or the 11 o'clock?
I think SAP would do well, but based
Okay.
on my interactions with him, I think he can resolve this case.
Okay. Is there any conditions to this bond, Judge?
No drugs, alcohol, weapons, or guns while on bond. And I don't know, was there a stay away or anything?
The victim is on the line.
Who's the victim?
Mr. Wallace, I think.
And Mr. Akron Wallace. Mr. Wallace, do you want to say something to the court?
Yes.
You have to put on your camera, please. Raise your right hand for me.
Again, can you hear me?
I'm sorry?
So can you hear me?
I can. Raise your right hand.
I was saying, this is the case that was in front of the Capitol, right?
I'm sorry?
Is this the case that was in front of the Capitol?
Enoch Baisden.
Yes.
We just continued to address his bond at the 1,500 preset bond. We can move on. I don't think he's in a position to talk or the location.
Yeah, I'm not in a position to talk.
Okay, can you, we'll go ahead. He's still on bond with the $1,500, okay? And we have no further contact with the victim. Okay.
Yes, Your Honor.
Okay, thank you.
There, no further contact with the victim, and that's it.
I don't know. Did the state ask for stay away as well?
We did. We asked for a stay away from the incident location.
Which is 201 Washington Street?
It's, yes.
Okay.
Okay.
What was that bond, Judge?
1,500. $1,500 surety.
Thank you.
We done?
Yep, we're ready, Miss Lewis. We're waiting on Miss Lewis.
Give me 1 second.
Okay.
All right, we'll start with the reset date for the SAP is going to be December the 4th. It's on a Thursday. The add-on counter, position number 1 is a $1,500 SOB through the jail. Reset further notice. Position number 2 is a total of
I got 11,000.
Yep, yeah, I was gonna say 11,000, reset for SAP, December 4th. Going to the original counter, position number 1 is $1,500 surety, reset for SAP. Position number 2 is $1,000 surety, I just reset it for SAP. She didn't make bond. Yeah, I say she was in the process, but just for precautions.
Yeah.
Position number 3 is a total of a $2,000 surety, $1,000 on each charge, reset for SAP. Position number 4 is a total of a $3,000 SOB through pretrial level 1, reset further notice. Position number 5 is a total of a $3,000 surety bond, $2,000 on the first, $1,000 on the second charge, reset for SAP. Position number 6 is a $1,000 SOB through the jail, reset further notice. Position number 7 is a $4,000 surety bond, reset for SAP. Position number 8 is a $2,000 surety bond, reset for SAP. Position number 9 is a total of a $3,000 SOB through pretrial level 1, $2,000 on the battery, $1,000 on the hinder. Person making an emergency telephone call. Position number 10 is a $1,000 SOB through the jail, reset further notice. Position number 11 is a total of a $2,000 SOB through the jail, $1,000 on each charge. That was number 11. Position number 12 is a total of a $3,000 surety, $5,000 on the first, $2,000 on charge 2, and $500 on the third. A total of a $3,000 surety, reset for SAP. Position number 20 is a $1,000 surety, reset for SAP. Position 21, I have a total of a $2,000 SOB through pretrial level 1, $1,000 on the first, $500 on the second and the third. Position number 19, I have a total of a $3,000 surety, reset for SAP. That's $250 on charge 1, 2, 3, and 6, and $1,000 on the reckless, and $1,000 on the DUI.
What number you on?
I'm on position 13. Oh, I'm sorry. That was
You said
19.
I
I'm
was wondering
sorry.
you going in reverse.
I'm sorry. I had my papers out of order. So sorry. I gave y'all 19. My bad.
Cause I'm sitting here like, did I miss 13 through 18?
Yeah, you did.
It's Saturday.
I'm sorry. My stuff was out of order. That's why
Sorry.
y'all had me jump so quick. Y'all was like, Miss Liz, you ready? And I was trying to get my stuff in order. Okay, I do apologize for the jumps, but
Okay, so go back.
everybody got 11 and 12, right?
Right.
Okay, 13. I got my papers in order now. I do apologize. Oh my God. All right, position 13 is a $5,000 SOB through the jail, reset further notice. Position 14 is a $4,000 cash bond only, reset for SAP. Position 15 is a total of $1,500 surety. That's $500 on each charge, reset to SAP. Position number 16, I have a total of a $2,000 surety, but I did not get the breakdown correctly. Is this $1,000 on the DUI and then 500 on the, what was the rest?
250 on the other 4.
Okay, $250 on the other 4. Okay.
Yeah.
Okay. I'll make that correct. Okay. I was gonna say. Okay. Position number 17 is a total of a $5,000 surety, $4,000 on battery, $1,000 on the simple battery set for SAP. Position number 18 is a $1,000 surety, set for SAP. Mr. Tucson, are you, Mr. Howard, I'm sorry, y'all, we surrendering the other case?
Yes.
I think you said it was, yeah.
Okay, I just want to make sure I put that out. That case will be also reset to December the 4th. Position number 19, I did give that earlier, but I'll go back over it, is a $3,000 surety, reset for SAP. Position number 20 is a $1,000 surety, reset for SAP. And 21 is a total of a $2,000 SOB through pretrial level 1, 1,000 on the hit and run, 500 on the other 2 charges. Any clarification? I'm so sorry about that.
That's
The
okay.
add-on one got me. I think I had my paperwork all crazy, but I do apologize for that.
No worries.
Welcome back, Judge.
I know.
Thank you.
And my
I
condolences to you. I'm so
appreciate
sorry.
it.
I never got a chance to shout out my condolences to you. I do apologize for your
Thank
mom.
you. Appreciate it.
Yes,
Thank
same here, Judge.
Thank you. All right. See you all next time.
All right. Don't jump ship on me, Judge. I got to get these orders to you.
I will. But buzz me. Thank you.
Okay.
Have a good
All right.
Thank you.
Everybody have a
All
good
right.
day.
Bye. You
Bye.
too. Bye-bye.
All right.
Yeah, have a good weekend.
Oh,
You
send me
too.
those waivers, Mr. Bartell. Oh, I get them.
Yeah.
All right. Thank you.
All right. Bye-bye.